3 weeks after she buried her husband, Margaret found out she only owned half the house she and Frank had spent 30 years paying off. And look, I know checking the paperwork on your house sounds about as thrilling as a 4-hour documentary on the history of drywall. It's the ultimate I'll deal with it later task. But later is about to become the most expensive word Margaret ever used. Because she didn't lose half her house to a lawsuit or a lien. She lost it to 2 words. 2 words that were supposed to be on the deed and were not. And she and Frank did everything right. They bought the house young. They paid extra on the mortgage every single month. The day it was finally paid off, they burned the note in the backyard like a couple of suburban anarchists. Both their names, right there on the paper, side by side. Didn't matter. The day Frank died, half of that house, her house, the one she was still sleeping in, got pulled into a courtroom. Months of it. Lawyers, filing fees, a judge sorting out who owned what, in the home she'd lived in for 3 decades, over 2 words. And here's the part that should make you a little angry. The fix was free. So simple, it's almost criminal that nobody, not the bank, not the title company, not the guy who slid a mountain of papers across the table while you signed your name 70 times, ever bothered to mention it. If they did, they didn't explain it good enough. Because right now, there's a piece of paper in a drawer somewhere in your house, your deed. You signed it once, probably years ago, and I'd bet money you haven't looked at it since. By the end of this, you're going to know whether it's got the 2 words that protect your spouse, or the 2 words that hand your family to a courtroom. My name is Matt. I buy houses for a living, going on 20 years now. I'm not an estate attorney, but I've sat at enough closing tables to tell you the most important document in your entire financial life is the one nobody ever bothers to explain. So let's start with how this actually happens, because Margaret and Frank didn't choose to put half their house at risk. Nobody does. The system chose it for them, quietly, by default. When you bought your home, you signed a deed, and unless somebody specifically walked you through the exact language, unless you knew to ask, that deed almost certainly listed you and your spouse a certain way, automatically. In many states, when 2 people are on a deed and the paper doesn't say otherwise, the law assumes something called tenants in common. Tenants in common. Sounds fine, right? Sounds like a community garden where everyone shares the tomatoes. Well, it's not that. Tenants in common means each of you owns a separate share. Your half, their half. 2 pieces of paper stapled together. And when one of you dies, your half does not automatically go to the other one. It goes wherever your will sends it. And if a will is all you've got, that usually means probate. Yeah, court. So Frank's half didn't go to Margaret. It went to a judge. That's the default. That's what, well, both our names are on it, actually buys most people. A door that looks shut, but the deadbolt was never thrown. Think about your own front door for a second. Tenants in common is a door you pulled closed behind you. Looks locked. From the street, you'd never know the difference, but the deadbolt never turned. Anybody who leans on it walks right in. The 2 words they were missing on their deed are the deadbolt. And here they are. The words you want are joint tenants. The full phrase is joint tenancy with right of survivorship. When your deed says you and your spouse own the home as joint tenants with the right of survivorship, the moment one of you dies, the other one automatically owns all of it, outright. No court, no judge, no probate on that house at all. The deed does the work the instant it's needed. Deadbolt thrown. Same house, same 2 people, same drawer. The only difference between Margaret stuck in a courtroom for 6 months and Margaret owning her home free and clear the very next morning is whether somebody typed those words onto a piece of paper years earlier. To add those words cost basically nothing, a few minutes. And the people standing in that closing room, the title company, the lender, the closing agent, they knew. It just wasn't their job to care. They got paid the day you signed. The bill for what they left off doesn't come due for 20, 30 years later. And by then, you're not the one paying it. Your spouse is. Now, most people would stop right there. 2 words, you're safe, let's roll the credits. But because I sit at closing tables for a living, let me give you the part even the joint tenancy crowd skips. Because those 2 words can save your spouse from probate and still quietly cost your family a small fortune, depending on which state you live in. Here's what I mean. Say you and your spouse bought the place years ago for $150,000. Today it's worth $750,000. That's $600,000 your house earned while you were sleeping. Great news, right up until somebody has to sell it. Because when one spouse dies and the other goes to sell, the IRS asks the one question nobody at the closing table ever explained. What's your basis? Basically, how much do we pretend you paid so we can tax the gain? See, there's a rule that helps here. It's called a step-up. When your spouse dies, their share of the home steps up to what it's worth the day they pass. Their old basis disappears. Here's the catch with joint tenancy. It usually steps up only their half. Their side resets to today's value. Your side can still be stuck back at the price you paid in 1994. So you sell, and on paper, there's still a gain on your half, and the IRS wants a piece of it. Now, hold on, because this is exactly the kind of thing people get wrong. That does not mean every widow gets a tax bill. No. There's a home sale exclusion that can wipe out up to $500,000 of gain if the surviving spouse sells within a couple of years and meets the rules. So I'm not telling you joint tenancy always costs you. It doesn't. What I'm telling you is that joint tenancy solves the probate problem and can leave the tax problem behind. And whether that one ever bites depends on stuff nobody's thinking about assigning. How long the survivor waits to sell, how much the place keeps climbing, your state's own rules. And that's the difference between a deed question and an estate planning question. Because in the 9 community property states, Nevada, California, Texas, Washington, Arizona, Wisconsin, Idaho, New Mexico, and Louisiana, married couples may have a better option. When one spouse dies, qualifying community property can step up both halves, not just the deceased. The whole thing resets. In that same $150,000 to $750,000 house, the entire $600,000 of built-in gain can simply just vanish for tax purposes. Same house, same marriage, same good intention, different paperwork, completely different result. So look at the ladder you're actually standing on. Tenants in common can blindside your spouse in court. Joint tenancy is a real step up. It keeps the house out of probate, but it can still leave that tax question sitting there. And community property only helps in the right states for the right couples with the right paperwork. Which is why, if you actually want to cover your bases, you stop treating your deed like a magic spell and you move into real estate planning. Usually that means an attorney putting the home into a properly drafted, properly funded trust. Not because a trust magically erases every tax in every state, it doesn't. But because a trust is where this stops being a random phrase on a deed and starts being an actual plan. Who owns the house if one spouse dies? Who controls it if one of you can't sign? Whether your title even matches your tax strategy. And that middle one is the part a deed can never touch. Because a deed only works when you die. It does nothing if you're alive but can't sign. A stroke, dementia, a bad accident. Then your family's right back in front of a judge, this time begging for permission to manage your own house while you are lying in a hospital bed. A trust covers that. It holds the home, passes it outside probate just like the deadbolt does, can preserve that step up, and it keeps working if you're incapacitated, not just when you're gone. If the two words are the deadbolt, the trust is where you throw the deadbolt, turn on the alarm, and install the laser grid security system. But I've watched too many careful, responsible people do everything right and still leave their spouse exposed because they trusted a piece of paper that was only ever built to do half the job. Sometimes the expensive mistake isn't buying the wrong house. It's owning the right house under the wrong paperwork. So here's what to do. Tonight, not someday, and this is the rare problem you can actually knock out in 10 minutes for free from your own couch. First, go find the deed. The drawer, the fireproof box, the folder from your closing, or just pull it free off your county recorder's website. Find the line that says how you hold title. Read it out loud. And then second, look at which words are actually there. If it says tenants in common, or it doesn't mention survivorship at all, that's the door that only looks shut. If it says joint tenants with right of survivorship, your deadbolt's thrown. But if you're in one of those 9 states, check whether community property is the smarter play for the tax side. The right answer depends on where you live and whether you're married, so that's a 5-minute conversation with an estate attorney, not a guess off of a YouTube video. And third, if you want the version that covers all of it, the probate, the taxes, and what happens if you're incapacitated, not to mention a little privacy via anonymity, that is the trust. And if you don't know where to start, you can connect with the team that does my stuff at protectwhatsmine.com. It's the first link in the description. Now, here's the honest truth about the clock on this. There isn't one. No deadline, no filing window, no 30 days to object. And that is exactly why people never get around to it. It's not urgent, right up until the single day it becomes permanent. And you don't get to schedule that day. Margaret didn't. So really, you've got 2 moves here. Move 1, close the drawer, tell yourself you'll deal with it later, and leave your spouse to find out which words were missing the hardest possible way. Or move 2, spend 10 minutes tonight, read 1 line on 1 piece of paper, and know, for free, while you're still here to fix it, exactly which side of that courtroom your family is going to land on. Pull the deed, read the line, and now you know what to do based on what it says. That's the whole assignment. Because while you're in there locking your own door from the inside, getting the words right, setting up the trust, protecting your spouse, a handful of states are quietly working on that same door from the outside. They've built something aimed right at homeowners. A tax you trigger, not by selling, not by dying, but by simply trying to leave the state. And that's why I pulled this next one here for you to watch next. And it's the same pattern every time. They start at the top, they sell it as fairness, then quietly expand it down until it lands on somebody who looks exactly like you. You'll see what I mean. Check it out. God loves you, and so do I. Take care.